Good morning, and thank you for joining us today.
We provide bold,
legal insight, and business leadership
to forward-thinking people and organizations.
We believe in better
and bold outcomes
and meticulous focus
in finding the solutions others might miss.
By building our practice around the best minds in the legal profession.
And outside of it, too.
We believe the pursuit of better starts with people.
Our colleagues, our clients,
and the people who depend on them.
We are committed to truly understanding
the individual needs
of those who depend on us,
so we can help them go from where they are
to where they want to be.
We are.
We are.
We are.
We are.
We are.
Husch Blackwell.
Husch Blackwell.
Husch Blackwell.
We are Husch Blackwell.
Good morning, and thank you for joining us today. I'm Dan Miskey. I'm a partner in Husch Blackwell's Milwaukee office, representing condominium and homeowner associations throughout Wisconsin. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience consoles, there are multiple application icons for your use during the program today. Please submit any questions during the webcast via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation, as well as a link to sign up for our blog, is available in the resources folder. This program is approved for Wisconsin Continuing Legal Education and has been approved by the Community Association Managers International Certification Board, CAM-ICB, to fulfill continuing education requirements for your CMCA certification. To report your CMCA hours, click on the CEU icon at the bottom of the screen. A certificate of attendance will be mailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your association's needs. This is all for the housekeeping item. Let's get started with our program. Today, we will be sharing with you the new 2020 Roberts Rules, how parliamentary procedure should be used to run meetings more efficiently, some case example of fine issues that arise and how to solve them, some basic collection reminders relating to death, trusts, mortgages, and why your rules matter more than you think. Joining me is the co-leader of our condominium team and my partner, Lydia Chartre, who along with myself has been admitted to the National College of Community Association Lawyers. Also with us, attorney Kataj Brown, who is a commercial litigator focusing on contentious business disputes in state and federal court and various condominium association matters. Senior paralegal Sandra Chapman, who focuses on condominium and homeowner association matters. Paralegal Billy Fothery, who works closely with attorneys and clients in preparing a wide variety of condominium documents to ensure effective representation in all aspects of community association law. And paralegal assistant Jody Slaby, who assists clients and legal teams with complex litigation in the real estate sector. So starting us today, Billy Fothery.
Good morning, everyone. I have to admit, I am extremely nervous for this. Something about the webcam just gives me chills. But if I can get through this without one of my children banging on the door, we've made it. So I'm just going to give you a little about collections, just a little about what happens if a person is deceased or if the property is in trust. We all know that dead men tell no tales, and usually dead men do not pay their. What happens? Two things can happen. If the person's deceased, there's either an estate or there's not an estate. If there's an estate, that just means that an estate was formally filed with the state of Wisconsin and how to disperse that person's assets. That makes things much easier for the condo associations. There's a person to serve, there's a contact. You proceed as normal with a collection. Again, we always recommend if an account is 60 to 90 days past due, that you send it to us for collections. Sometimes if you know the person's deceased, you might want to send it to us earlier because we can get in and make sure that we can get a claim filed with the estate. It's called a claim against the estate. It's something we would file with the probate court that says this debt is owed to the association. So that can be taken into account in the estate. So again, if you know they're deceased and you send it to us for collections, let us know. Sometimes you don't know they're deceased, but obviously that's why they haven't paid. So again, if there's an estate open, we proceed as normal. We have a person to accept service for them. Sorry, I forgot to click my slides. If there's no estate, that doesn't mean the association doesn't have options. We can do what is called a special administration. So we can petition the court to have a person accept service on behalf of the deceased person. Once we have that in place, we can again continue with the collection and the foreclosure process as we would normally do. So just because a person's deceased, the association does have options, and it's not something that you should look the other way with and hope that the unit or property gets taken care of at some point. We've had a lot where the deceased person has no family or no next of kin. So you could be sitting there for a really long time if you're waiting for someone to come and take responsibility for the property. So don't do that. Again, 60 to 90 days past due, send it to us. Let us know if they are deceased, and we will proceed with collection whichever way we need to, depending if there's an estate or no estate. The other thing that sometimes happens is that they put the property into a trust. Again, this is not an issue. We would proceed as normal with our collection process against the trust. So if a property is in trust or the person is deceased, treat it like you would treat any other unit owner and send it to us for collections at 60 to 90 days, possibly sooner if you know the person is deceased and there could possibly be something going on with the property or property transfer.
All right, thank you, Billy. Good morning. My name is Attorney Ketaj Brown, and I handle our team's condominium and homeowners association litigation. This section is going to be about condo and HOA litigation in respect to what seems to be a very highly contested topic, the assessment of fines against unit owners in respect to foreclosure litigation. And as board members and property owners, I want to provide you with a few key considerations to take into account when a board receives complaints of rule violations and then seeks to impose fines based on those violations. All of the information is based on actual cases that we are currently litigating, where the central issue is convincing the court that the association's assessed fines were imposed reasonably under the circumstances. And what we're finding out lately is that courts are heavily scrutinizing fines when the fines are solely being used as the basis to lien and ultimately grounds to foreclose, especially when the fine unit owner is current on their normal monthly dues and assessments. In other words, it's becoming increasingly difficult to foreclose on liens that are based exclusively on fines. However, I'm going to talk about 5 things to take into consideration which will make the association's option of fining, liening, and foreclosing a lot more straightforward and compelling to the court. First, follow your governing documents. This may be the most important factor. So if you don't listen to anything else I say, follow your governing documents. And if you don't like or agree with them, or your documents are dated or ambiguous, follow your amendment procedures to change them. A lot of associations have documents that are old and outdated and they don't apply to current situations. So amend them. Don't just sit on them, because if and when the association needs to rely on those documents to support a lawsuit and the documents aren't clear or don't pertain to current issues, the court is going to make its own decision, which a lot of times is not beneficial to the association. The court is going to rule by following your documents as written. So the association board needs to do the same, because any deviation from guidance provided in the documents could lead to a counterclaim by the unit owner for breach of contract against the association. It's important that the documents are followed to the T. Second, have a fining structure. Foreclosing on liens based on fines is 99% more successful when an association has a fining structure rather than just freestyling and imposing fines randomly at will. Not having a fining structure in place gives the court an impression that the board may not be applying fines fairly between all unit owners. This also opens up the association for counterclaims based on things like discrimination, abuse of discretion, and also raises doubts about general unfairness. Having a finding structure in place and following that finding structure to the letter demonstrates to the court that no unit owner is being treated unfairly and no unit owner is above the rules. Third, notice. If a tenant is occupying one of the units, make sure to send the correct letter to the tenant and also copy the owner. Wisconsin Condominium Ownership Act states that if a tenant of a unit commits a violation that results in a fine, the tenant is liable for the charge. However, in order to fine that tenant, the association must give notice to the tenant and the owner and provide written notice, which includes the amount of fines and language that states if the tenant fails to pay the fines within 30 days after receiving notice, the unit owner is now liable to the association for the unpaid amounts. And the tenant may later on be liable to the unit owner for any amounts of the fine that the unit owner paid. We're finding that many associations are not following this notice requirement, and both tenants and unit owners are escaping liability from rules violations and subsequent fines due to lack of notice. Fourth, don't get carried away with fines so that a court finds them egregious. This is a big one. Courts take issue when associations assess very crazy high amounts of fines before filing a complaint for foreclosure. For example, if a rule violation allows for, say, a $100 a day fine, if the association waits 6 months to file a lien on assessments based on that $100 a day fine that a unit owner fails to pay or remedy, it ends up being a foreclosure based on roughly $18,000 worth of fines. And that's not including attorney's fees, which a lot of times, and those fines a lot of times are unverified and unsubstantiated, and all the court has to go off is the board's word with no other evidence. This is a bad situation in court. Most time the court will not side with the association. So if you find a unit owner, do it immediately, provide credible grounds to support that fine, and don't let the fines get carried away. It's much easier to convince a court that, say, $300 worth of smoking fines is reasonable versus $10,000 worth of smoking fines. Fifth, if unit owners do not pay the fines and they ignore the letters that are sent, put the account into collections immediately and do not wait. This is the same rationale as my last point. When it comes to enforcing fines, don't wait. The more time you wait, the more doubt is created when we go to court. The judge will question if the violation and judge will question the violation and ask if this was such a big deal, why did the association wait for a whole year before suing? And that doubt, that's enough for the court to either reduce the fine on its own or dismiss the whole lawsuit by finding the fines unreasonable and egregious. So once a rule violation is received, investigated by the board and substantiated, it's in the association's best interest to immediately send the file to collections if a unit owner refuses to pay the fines. If association follow these key points, finding and enforcing fines in courts will be a much smoother process. Thank you.
Hi, my name is Jody Slaby. I would like to talk a little bit about locking debtors out of their account. Basically, as Billy said, when should you be sending the file to Husch Blackwell? Well, once an owner is overdue by 2 months, 60 to 90 days, send them to us for collection. Once you've done that, turn off their online access immediately. We don't want them to be able to see their account through your system just because it won't be accurate. It's best if they go through us to get any kind of balance or do any communication regarding the debt. We require that all communication regarding the debt be through us. So if you deal with the unit owner on your own, you're kind of giving away the association's money because it's not, your balance will not always be the same as ours. In fact, it will not be the same as ours. So we like to have all communication regarding the debt come through us. It just makes everything cleaner. There's no he said, she said, that kind of thing. It can all be through our firm. So what we do when we follow our collection system, we first send out a demand letter. We will then, if we get no response to the demand letter, we'll file a lien. If there's no response to the lien notice letter, we will then send a last chance letter. And if there's still no response, we will then proceed to foreclosure. The reason we do this is the more notices and demands that we send out, we'll have a court asking, why did you wait so long? And then on the other hand, if we don't send out enough notices, the courts will ask why we didn't give them a second chance and why we didn't wait and we rushed into foreclosure. So our system, it does really work. That's why we follow this system. It gets collection results. The assessments, we get past due assessments going forward. We include late fees. We go through the payments. We create our own ledger, which includes the assessments, the late fees, interest. We add our attorney's fees and costs for the filing fees, for the lien, for the other associated costs. And we can get that money back for the association.
Nice job, Jody. All right. Meetings, parliamentary procedure, and minutes, how to be efficient. So we're going to cover this. I stink at following slides. Let's just be honest. So I will do my best to follow the slides as well as I can. So we have a lot of slides, but mostly a lot of information to provide that I hope you guys find useful under the new rules of parliamentary procedure, which you'll be happy to hear didn't change all that much from the old rules, except for, let's say, relative to electronic meetings. So first, parliamentary procedure is designed to include everything to effectively run a legal meeting. And I've listed this stuff, but you guys already know most of this. You use parliamentary procedure probably more than most people do, only because you attend your meetings. And because you attend the meetings, you have to use it to some extent. Notice I'm saying parliamentary procedure, not Robert's Rules. Robert's Rules is just one form of parliamentary procedure, but it's the most highly used form. So the question becomes, what is it? Parliamentary procedure are rules of democracy. It's a commonly accepted way for people to reach decisions. And I'm going to move right on to Robert. Who was Robert from Robert's Rules? And, he was a soldier. He was actually a general at the end. He was a colonel when he wrote the rules. He was in Milwaukee. He was an engineer as well. He was a highly organized guy who wanted meetings to be run far more efficiently than they were. And his whole concept was to make meetings more efficient, orderly, and fair, so that everyone had the opportunity to say something, but no one had the opportunity to hog the floor and make it their long-standing speech. And the reason was to get stuff done, not to discuss things endlessly. And the key was that the rules, he was thinking his rules, but all parliamentary rules exist for the benefit of the organization. So if they're not working, change them. There's no law that says you can't change the rules. Now, your documents may say you've adopted Robert's Rules, and then to change them, you've got to follow Robert's Rules to change Robert's Rules, but there's even a way to do that. You'll notice I talk about the agenda, that the agenda is not on your side, and it's not on your side because you run out of time always at these meetings, and the stuff at the end always gets the least amount of attention. So if you look at your agenda and you go, okay, what do we care about? Normally, one, you need to care about a quorum to make sure you have it. Two, you need to get rid of the approval of the last meeting minutes so they're approved so they can be published. Three, unit owner comments. I only put it there because this was assuming a board meeting, but these rules apply equally to unit owner meetings. But even on a unit owner meeting, you may have a period for unit owner comments, but obviously you could transpose unit owner comments and put in officer reports and then committee reports and move it around a little if you're using it for a unit owner meeting instead of a board meeting. End of the day, set times, follow the times, and you will be much happier with the results of your meetings. So, meetings, what you need to know. Follow the agenda. Discuss one item at a time. You already know that. Give each board member a chance to speak. You already know that. The president or chair should talk the least amount on an item until you're closer to the vote. Why? Because if you really want to hear what people think, you can't dominate the conversation with what you think and then go, well, now what do you think? It's kind of like the parent who does that to the child, and magically the child thinks exactly like the parent thinks, because they know if they say that, they're going to get their ice cream. And otherwise, no ice cream. So what you want to do is hear what everybody says, address questions and comments to the chair. That's really designed around solving one problem, which we all know. When unit owners are talking to each other, and sometimes when board members are talking to each other, they may not be the most gracious and kind-hearted, or they may intentionally run into a conflict with each other that doesn't benefit the entire conversation. The concept is to provide information, provide facts on which everyone can make a decision, not to win a one-on-one argument with the other unit owner or board member. All that does is make the meetings longer. So the tone matters. And I say that because we've been at meetings, all of us, where the goal is to deal with an issue. It's going to be a tough issue. But I think these slides, and I stole these from CAI, are a pretty good example. If your relationship is more like the person in the top part of the slide, and you present it more in that fashion, in a welcoming fashion, you're more likely to get information back. And if you present it in the fashion that the person on the second one does, you're not going to get much, or you're going to get a fight back. That's not going to help you. Minutes. We've said this a million times. You guys already know this, but I'm saying it once more. Record what was done, not what was said. The good news is the new Roberts Rules of Order have even more details on what should and should not be in the minutes. So the basics: association name, type of meeting, date and location, attendance. You guys already know all that. Body of the minutes, approval of the prior minutes. If you don't have the handout, you guys can PDF this and get the handout for this. So I'm not going to spend time going through how the meeting works and what do they look like. You know, if your agenda's long, your minutes are likely going to be long, but your minutes should match your agenda. That was the point of the prior slide. In fact, I'm going to go back to it just for a moment. What do they look like? What do your minutes look like? They should look like the agenda, but have decisions that are made as part of it. Not, obviously, like Tolstoy's book, which some minutes look like, trust me. So the business of the meeting, no discussion without emotion. That is the hardest one that I have getting anyone to follow. Is if you don't have emotion on the table, you don't have a decision to make. So why are you talking about it? And notice I said discussion. You're still allowed to have the president's report, the treasurer's report, the committee reports, but these are reports. They should be 3 to 5 minutes at most, and they can certainly be, we have no report this month. That's great. So then you get to the motion, how they work, what it is, resolution motion, the motion passed, the motion did not pass. That's what's in your minutes. You know, you have to have the motion, and then what happened. And you'll notice I sort of just laid it out here so that you would have it. All of the stuff I've just covered is sort of the background 10 minutes to where we're going. By the way, executive sessions are also more thoroughly covered in the latest Robert's Rules of Order. This is the old one, and I'm showing it to you. I'm trying to punch through these real quick. I'm showing it to you so you get an idea how long it is and the tabs I have on top for me to use. And I'm going to get a kick out of this when we get to the new one, because we know how new ones work. You know, this is what we've learned in the past. I used my first 10 minutes to describe what's happened in the past as to how we've done things. That system still applies. So I feel like I'm missing something, but that's okay. I'm going to cover, I did not mean to switch to Sandy, so I'm going to switch back. Give me 1 second here. Sorry about that. I'm just going to punch up to the last one. Sorry. So this is the thickness of Robert's Rules of Order. The book, I've just gotten it, to be honest with you. This is the old one. The new one looks almost identical, but our offices are closed today, so I can't show it to you because it's white. And otherwise, it is roughly, this one was, and I don't have it sitting here at the moment, 767 pages. I'm sorry. Here we go. This one was 716 pages. And with the addition and all the new stuff and all the cute stuff, the new one's 714 pages. So we saved 2 pages. And you're like, good, we took stuff out. No, they made it slightly bigger and they put more words on a page. So it actually has a little more stuff in it than the old one, but you feel better because it's 2 pages less. That's probably my favorite thing about the new book. There was a ton to go through in here, obviously, and to try to digest it. I didn't have a chance, honestly, to digest it in a fashion that would make sense to everybody from the standpoint of putting on PowerPoint slides, and I didn't want to try to rush it on there. But what I did do was put a list together for myself, and I will be doing a blog on this that talks about what do you care about. So the things you care about. There's now 15 pages of sample rules. So if you don't know what to say, like you're stuck, it sort of leads you through the right thing to do for sample rules for electronic meetings, which is kind of handy. So that will be within the book. We'll find a way to share as much of it as I can without violating any copyright rules. It talks about different types of electronic meetings and their rules, because it might differ depending on whether you're all on the phone, whether you can see each other, whether people are going to be showing stuff like I showed you Robert's Rules, whether they're going to be showing you stuff and normally how it would work. I told you about executive sessions, the secrecy decisions and what's in minutes, what's not in minutes, and the lifting of the secrecy, how you can do that legally, or how the Roberts Rules requires you to do that in order to lift the secrecy of those executive session minutes. The secrecy of ballot votes. Are they supposed to be secret? Aren't they supposed to be secret? If they are secret, how long are they secret, and what you're supposed to do with them? Ratification of actions taken at an unauthorized electronic meeting. I know many of you don't have anything in your bylaws that authorize having electronic meetings or otherwise in your condominium documents. This is a way, if you've taken some action, to go, okay, we've taken some actions that potentially we don't have the authority to take because we did them through electronic meetings and our documents don't let us have electronic meetings. This is a way to ratify those actions. It's a one-time thing. You don't get to keep ratifying actions because you keep acting illegally. But is my advice. That part's my advice. That's not in Robert's Rules. I'm just saying you can't pretend as though the rules say something they don't say and continue to act outside the conformity with those rules, with the goal being, oh, don't worry, we'll ratify it later. It'll all be fine. Because sometimes it doesn't get ratified by the next board. I don't care about that one, don't care about that one. Points of order are discussed more. For really the purposes of this meeting, this presentation and the concept, so was to stress to you Robert's Rules, what they do, what they don't do. They're not short. They are extremely well organized. If you're looking for something, the index itself is crazy long, and there is a glossary of terms, or I forget what it's called. The table of contents is also long and detailed as to what it is you care about. My last point, the key point of Robert's Rules, it is not to be used as a sword. This is not, gotcha, you didn't know about rule blah, 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 and I was able to catch you violating it, and now you're kicked out of the meeting or whatever it is you want to say. The rules are designed to make the flow of information efficient, and so decisions get made. Remember that. It's a sword. It's a sword to protect people who don't want to listen to someone talk for 25 minutes about why their sidewalk wasn't shoveled, okay? That's the shield. The shield is, we get it, you're upset, your sidewalk wasn't shoveled. Got it. We'll solve that, or we'll figure that out. That's a 15-second discussion, not a 25-minute explanation. That's what the rules are meant to deal with, how to get decisions made effectively and efficiently. Thank you very much. I will now pass it on to Sandra Chapman. It's yours, Sandy.
Hello, everyone. Good morning. Now you get to hear about mortgage foreclosures. Is everything now lost, or is it really? So I'm going to try and do this. I've not done my PowerPoint on my own before, so bear with me. I have a poll question for you. When the association is served with a mortgage foreclosure, do you get your attorney involved? Check yes all of the time, or no, never, or some of the time. I'll give you a few seconds to answer that, and we'll see the results shortly. Okay, well, this is great. No one said never. That's certainly correct. We like to hear that. And right now, currently due to COVID and the moratorium, your mortgage foreclosures may be down. However, once that moratorium is lifted, we anticipate that will change quickly. So we want you to be prepared for that. So obviously we've seen that you don't throw them away, and most of you send them to the attorney all of the time. Why do you want to have the mortgage foreclosure monitored? Well, there's several reasons. The only way the association has a chance to recover surplus funds is by filing that notice of retainer and claim of right to surplus. It's a relatively inexpensive thing to do, and it includes normally just one court filing, that notice of retainer. It also allows the association to know what's going on in the case. Has the owner worked out a payment plan with the bank, something you wouldn't know otherwise? Has there been a delay for some unexpected reason? Maybe they're discussing things behind the scenes or what have you. And if there is that delay, what are the association's options? And we walk you through that process and give you what your options are. Also, when the matter's concluded, should it go all the way to sheriff's sale? Who's that new owner? Was there a third-party purchaser? Did it go back to the bank? And we can provide you all of that information, including the day that they become responsible for paying their assessments going forward. Can the association possibly recover? Is it even worth their while? Yes. This year alone, even with the slowdown in mortgage foreclosures, there were several associations that were able to be made whole because there was enough surplus in that sale. There was another association that was partially paid. It's money that they would not have had we not been monitoring that foreclosure. We also find if there's surplus, we check that out, and we'll even go and seek third-party purchasers. We have people that are interested in purchasing properties. So we try to be aware of that and find that money for the association for it to get paid and to recover those funds. It's very much worth your while, just for all of those reasons that we've listed. And it provides you valuable information, and then in those cases where you get paid, that makes everyone much, much happier. So that's my little takeaway for today, and enjoy the rest of your day. I'm now going to turn everything over to Lydia.
Thank you, Sandy. Good morning, everybody. Thank you for spending some of your time this morning with us learning about rules. Dan's presentation focused on Robert's rules, and now we're going to get down to your rules, your association rules. And what I want to pitch in this presentation is that rules are useful tools to the association. You just have to follow a few simple guidelines to make sure that those rules work for you. So I want to be cool like Sandy and start with a poll question. So here we go. Did you find that owner complaints increased during the lockdown or the pandemic? Answer 1, yes, owner complaints have increased significantly. Number 2, no, owner complaints have decreased actually during COVID. Or third option, owner complaints have stayed the same. I'm going to give you a couple of seconds to get your answers in, and then we'll look at these results. Okay, I can't wait any longer. Let's find out. Interesting. So it sounds like for most of you, the owner complaints have stayed pretty much the same. The second response with the most yeses would be yes, owner complaints have increased significantly. And a few of you said no, owner complaints have actually decreased. Man, I wish I was hearing more from you guys, but I gotta tell you that my experience through the pandemic has been the owner complaints have really gone through the roof. And I've heard that from a number of you that are on this call today, just working through all the craziness that's been going on. One theory is that people being home more, they have more time to check their surroundings and find things to complain about. More people home means more noise complaints. So there's been a lot going on in the past year that we've had to deal with. And COVID really has shown us how useful your association rules can be. Why? Because typically they can be created and amended by the board alone. Now, I caution you to check your documents very carefully, because sometimes it does say in the declaration or bylaws that a majority owner vote is required before rules can be passed or amended, sometimes more than a majority. So it's worth a look before you pass rules as a board to make sure that you actually do have that power. If you do, it's useful because when the board can change rules by itself, of course, they're more easily changed with the times. And as COVID has shown us, there's been multiple occasions where temporary rules can really be helpful for the association, related to use of the amenities, related to use of the pool, your clubhouse, exercise facilities, decreasing the amount of people that can use it at a time, just to accommodate the health situation that's been going on. But you do have to watch out when you are passing rules as a board that they don't hammer back at you. If you don't follow these guidelines, there can be some dire consequences for the association with the board passing some rules. You certainly don't want to find them ultimately unenforceable by a court, because what did you do this for? And we just spent a bunch of money to find out that we can't enforce the rules that we passed. And you certainly do not want your rules to be found selectively enforced. And selective enforcement can come up in two different ways. One, either the board is enforcing the rules against one owner at the exclusion of another, meaning you really like this person, so we'll just let that slide. But for the other person that we don't like, we're going to make sure that they follow this rule. The other kind of selective enforcement would be as a board that you decide to enforce certain rules while turning a blind eye to others. Both of those things can lead to dire consequences with your rules. So keep in mind, and we'll get into this a little bit more in these slides too. So we'll go through a few don'ts first. Certainly don't make any rules as a board that conflict with your declaration or bylaws. There's a statute in the Condominium Act that tells us very clearly that there's a hierarchy in your condominium documents, meaning the declaration comes first, then the bylaws. The bylaws can't conflict with the declaration. If they do, your bylaw is unenforceable. And your rules are at the bottom of that chain. So if you make a rule and it conflicts with something that's currently in your declaration or bylaws, that rule is on its face unenforceable. So it's not going to do you any good. So as a corollary, don't think that you can fix something you don't like in your declaration or bylaws just by passing a contrary rule. That's not going to get it done. If you don't like something in your declaration or your bylaws, we need to amend that portion of the declaration or bylaws. Don't make rules as a board and keep them a secret. Notifying the owners is a very key component. In fact, most bylaws require that you mail notice of any new rules or amendments to your unit owners, and it won't be effective until they have that notice in hand. So don't think that you can just simply vote on it at a board meeting and have it reflected in your minutes, and somehow that is good enough notice for your owners. No, you should have a separate mailing to those owners. If your bylaws allow you to send notices to your owners by email, great. You can just send them a quick email with the new rule language and tell them to keep that in mind. But do check your declaration or bylaws for specifics on how rules need to be communicated to your homeowners. And if you have any questions on that, just ask. Don't make rules that violate the law. And when I say the law, I'm really talking about federal laws and state laws. And I'll give you a few examples of the ones that come up quite often when I'm looking at condominium documents. And frankly, sometimes these problems are in your declaration or bylaws, not just in rules that the board passed. So beware of that. One example is prohibiting satellite dishes. I can't tell you how many documents I've read that were even recently written by developer attorneys for newer condos that says nobody can put up a satellite dish. Well, I'll tell you that violates federal law. And so be careful of that. Also be wary if you see something in your documents that says the board has to approve placement of a satellite dish. That's been found to violate the federal law as well. So there's some really specific rules that we can pass that will help the association identify where the locations are that still fits within the federal rules, that satellites can be placed. We can make sure that the owner is responsible for putting it up, taking it down, fixing any damage, that kind of thing. But there are some very specific things that would violate federal law that we have to be careful of. So again, if you read your rules or your declaration or bylaws, see something like that in there, let us know. We'll have to fix that to keep you out of trouble. Second example is rules that target children. If you have anything that targets children in your documents, and you can identify it basically by using the word kids or children, that could be potentially harmful because courts have found that that's discriminatory on the basis of familial status, which means people that have kids and family. If you have rules that target children, your documents may be found discriminatory. So we want to be real careful about that. Very small, slim exception to that would be if you've got something that's very safety related, meaning that you have this rule for children because of safety issues. If that's the case, then we can talk about the parameters there, but those are a pretty narrow exception. Pools, exercise equipment, that kind of thing, we might be able to get away with it, but we have to be careful about the wording. Final example on a rule that might violate the law is saying that people cannot have emotional support or service animals. It is okay for condominiums to have no pet rules, as probably many of you live in communities where pets are not allowed. But if somebody comes to you who has an emotional support animal request or a service animal request, those need to be taken on a case-by-case basis. We look very carefully at the facts and whether they have the support for having that animal. So having a rule that blankly says no would certainly violate the federal law. I think this is my last don't. So don't put rental caps in your rules. Any kind of rule about rentals that restricts who can rent in your association, meaning some units are okay, some units should not be rented, say only 10 units in our association can be rented, that kind of thing. If you make a rule about that as a board, you have to be really careful because there's some case law precedent in Wisconsin where the Supreme Court basically said, listen, passing a rule with a rental restriction isn't going to be good enough. Those kinds of use restrictions really need to be in the bylaws or the declaration in order to be enforceable. So keep that in mind. All right, enough of the don'ts and the negativity. Time for some positivity here. What should you do as a board when you're thinking about making rules? First get rid of rules you don't enforce. Boards, you should be looking at your rules on an annual basis, not just your rules and regulations, but also your declaration, your bylaws. Give them a read, know what's in there. And if there's anything that you see that you're not enforcing or don't want to enforce as a board, let's change it. Let's get it out of there. For the reason I talked about earlier, that selective enforcement idea, if you're not enforcing all of your rules of the association equally, you could be accused of selectively enforcing them, which basically takes all the wind out of your sails as a board when you're trying to enforce something you do care about. So if there's something you don't enforce, get rid of it. Do enforce your rules equally and consistently. Again, as a board, you really do have to run that association as a business. As managers, you'll keep your boards in line this way. Remind them that you have to enforce things consistently. It's not based upon, we like this person, we don't like this person. We just run it as a business and we make those decisions. And the best way I've found to keep you on track as a board is to have a really good, clear enforcement policy that has a fine structure built into it. Kitaj talked about this a little bit in his presentation. If you give your unit owners notice or your lot owners that this is what's going to happen if you violate the documents, you're going to get fined this much, then you're going to get fined this much, and you make it very specific and clear, you have a much better chance of actually collecting those fines and having them be enforced by a court. So make sure you have that in place proactively and then follow it. And it gives you, if you've got a good policy, it gives you step-by-step so you don't have to reinvent the wheel anytime somebody violates. Do require your owners, if they're complaining about somebody else, and this is exactly what we saw run rampant during the lockdown, to put their complaint in writing. Don't let them just call up the board or the manager and say so-and-so did something and then expect the board or the manager to do something about it. Why? Because going forward, if you're trying to enforce the violation, this is evidence. You need evidence as a board to enforce your documents. So have the owner put it in writing. Certainly encourage photos, videos. Everybody's got a smartphone in their hand these days, so it's pretty easy to do. Document the violation so that there's little room for argument. That'll save you time, that'll save you money, and it'll cut to the chase a lot better. And if you have owners that say, I don't want to be a tattletale, well, then maybe it's not enough. Maybe it's not a big enough deal for the board to get involved. They really have to be involved in this situation too. Do warn about the violation once and then move on to fines. You do want to warn people according to your enforcement policy, at least for the first time. Why? Because it promotes due process within the association. You know, you may have one owner that's got a vendetta against another, and they're complaining about that person all the time. Well, before you start slapping fines on the other, send a warning, because that gives them an opportunity to say, hey, you know, I didn't do that, or that wasn't me. It provides an opportunity to make sure that the process is fair for your unit owners. So I would certainly recommend warning if you can. That is all I have on rules, and we've got lots of time for questions today, guys. So I think we're going to open it back up to the whole panel. And I know some of you have been putting in questions on the Q&A, written questions, which is great. And we've been answering those as we can. But here's your opportunity to continue to do that. And we will read through and get you some answers there.
So one is, I've answered a lot of the questions. As I've been going through, I've been trying to go from the oldest to the newest. It's 9:20 and we're up to about 9:14. But so we will, between Lydia and I and everybody else, try to read off some of the answers, and maybe all of us can throw in our thoughts on answers. So one person asked, can you have an annual meeting via Zoom during the pandemic? Lydia, this one's yours.
Lucky me. I've answered this question about 100 times since the pandemic started, I think. Well, the easiest part would be if your bylaws have been updated recently to allow for virtual meetings and electronic voting. For all of the bylaws I've been amending in the past couple of years, those are provisions that I always recommend that you put in, because keeping up with the changing times, it's great to have another alternative to an in-person meeting. But I know from the phone calls and emails that I've gotten from all of you that most of your documents are not up to the 21st century standards yet. So here's what you do. Can you meet virtually? Probably, but you have to take these steps. You need to take advantage of that one part in your bylaws that says you can attend a meeting as an owner, either in person or by proxy. When we're dealing with virtual meetings, it's the by proxy part that we want to take advantage of. So if you're going to have a meeting by Zoom or some other video platform, you'll want to use, with your notice of meeting, you want to send out not just your typical general proxy that somebody could give to another person and that person could attend the meeting in their stead. You'd want to use a directed proxy, which would appoint one of the board members to be the proxy holder and the proxy voter at your association meeting. And because a lot of people would rather keep their voice and cast their vote the way they want to and not just put every decision in the hands of the board, this is where the directed part comes in. So anything at your meeting that's going to be voted on, whether it's a bylaw amendment or a vote for board of director candidates or approving the last annual meeting minutes, you would list those things as if it's a ballot underneath your general proxy and allow the unit owner to then fill in how they want to vote for all of those items. So then when you get to the actual meeting part, the board will be running the meeting. Everybody can attend if they want to observe and participate and talk. But for the voting parts of the meeting, that proxy is going to be counted by the board member that's serving as the proxy. And as long as there's enough there, so you have quorum, you can continue, and they will run through the agenda and count the proxies as they go. So that's kind of the way you get around your documents not specifically saying virtual or electronic meetings are okay. You have anything to add on that?
No. I liked your answer. I was going to read the next one. I thought maybe you and I could take turns, and if anybody else wants to jump in, Kataj or Sandy or Jody or Billy, feel free. So one of the questions was, how about rules of the dock? Kids not allowed on dock without life jackets. My answer is this ties in a whole bunch of things. One being the board can pass safety rules anytime they want, so they can require life jackets on the dock. The part where it says kids is the problem. What you can't do is discriminate against familiar relationships. In other words, kids. And you can't have rules that discriminate based on children. So this would have the implication of discriminating based on children. I understand everyone would argue, no, we're concerned about children's safety. What, we don't care about adult safety or aged people's safety or geriatric safety? We only care about children's safety? The answer is obviously no, we care about everybody's safety. So if you care about everybody's safety, require life jackets for all or no one, but don't put the word children in any of your rules, because you're just asking for a lawsuit that you will lose and pay the other side or pay attorney fees. You see one you like, Lydia?
I was thinking, Sandy or Billy, could you guys look at the Q&A list and maybe kind of act as moderator and throw some good stuff at us? It's just hard to look at the questions and answer at the same time.
Well, I'm going to go with the collection question. And there was a question on when there is a sheriff's sale, where does the opening bid come from? Good question. In a mortgage foreclosure, it would be what is owed to the lender. So they prepare the opening bid. In an association foreclosure, it is the debt that's owed to the association. So that would include the dues, the late fees, the interest, the attorney's fees, and the costs up and through the day of the sale. So the debt doesn't stop when the association gets their judgment, but it carries on through to the sale. And so the association, and I know this is a misconception sometimes, the association gets real concerned that they're going to have to pay out money. They do not. The debt owed is what is bid, and therefore it's already been, shall we say, paid out. So no more money is spent by the association to give that opening bid.
Great job.
Yeah. One of the questions, I'm having a hard time understanding it, but it seems to be saying if somebody wants to install a satellite dish not on a rooftop, or on a rooftop that's common element, or on land outside the unit, can they do it? The simple answer is no on land outside the unit, probably. The issue is reasonableness. It generally has to be unit owner controlled. So limited common element, yes, which is why you see so many of them on decks. And other spaces, probably no, but then you could get into other arguments depending on why they need the satellite dish. I hope that answers that one.
I could add to that, Dan, if you want.
Good. Yeah, go ahead.
I've been writing a lot of these rules lately. So yes, what the federal law says is you, as an association, you cannot restrict placement of a satellite dish or an antenna on areas that owner solely possesses and controls. That means the unit and limited common element. So like Dan said, that's why you're seeing a lot of satellite dishes on decks and patios. You're probably going to run into a situation now and again when an owner can't really place that dish on the limited common element because it's obstructed. They can't get a good signal. So in those cases, you have to be a little bit more flexible as a board, and just saying, no, you can't place it anyplace else is probably going to get you in a lawsuit. So I've had some associations give a little with a pole placement, say right outside of their concrete patio, which is slightly on the common element, but not really. And I have seen some associations allow on the roof, but we have to just be real careful that we have the rules in place that puts the onus on the owner for any damage that might occur, so that they're responsible for that when it goes up and comes down.
Wait, now my favorite question. Kataj, you're going to be on. Can an association fine someone for repeatedly not wearing a mask? Nothing like tying politics into this and everything else.
That's a rough question. I believe this is rough. I think that an association, if they vote to put fines out, the fine can be a part of the governing documents. Now, the real question is whether the fine will be upheld in court if the association files a lien and tries to foreclose on it. So that's the real question. And if that circuit court Wisconsin judge doesn't have any type of governing law or policy that I guess requires that mask to be on at that particular moment, that particular time, I guess assuming this is the common areas of the association, then I don't believe there may be a basis to go ahead and assess that fine. So that's the best way I can say it. I mean, the association is free to vote on rules as long as those rules are not, contrary to any type of statutes or laws. And if the majority votes on them through the process that the governing documents allow, then those are the rules. Again, those rules can be there, but whether those rules stand up in court is a whole different story.
And even, so I'm going to add to that, even without the existing, let's just say, fight between the legislature and the governor as to the mask mandate, not mask mandate, the not mask mandate lasting a whole hour before the governor signed a new order saying, yes, I'm going to have a mandate yesterday, if I understand the timing correctly. You also have the issue of, can an association fine? The answer is yes. You can fine. Whether it'll be enforced, who knows? So, and what would you use to fine? Presumably your rules, decks, documents aren't going to have a provision that says you absolutely have to wear a mask in these following locations. So due process will be an argument of the other side. I didn't have notice that you would fine me for that issue. At the same time, the fine could be for something like nuisance, noxious activity, hazardous activity. I mean, those are the types of things that usually are within the documents, or failing to comply with the law and then argue the mask mandate is legal versus not legal. You could get into a ton of issues here. I'm gathering just by the tone of the question that there's a person who just refuses to wear a mask regardless of whatever you do. You've got to decide, is this a battle worth fighting? If it is, go ahead. But recognize your association may spend a significant amount of money trying to enforce it. You could win, you could lose. All right, onward.
Let me throw out a kind of a corollary question that I saw from the Q&A, kind of is directed at Kataj too. If my board wants to enforce a fine and make sure it's enforceable, what kind of good proof do we need to make sure that we have in place?
Sure. So my mantra for enforcing fines and having backup for them is the more the better, right? So what we are trying to do is we're trying to paper the record. We're trying to provide enough evidence, whatever that may be, so that the judge comes to an understanding that the board was correct in assessing the fine. So whether that be photographs, whether it be documentary evidence, whether it be affidavits, testimony from some of the other people who live in the community, other board members and things like that, the more the better. And I don't, Lydia, I don't see the question, but I don't know if I answered it totally fully.
I think that, like, what kinds of things do they need to gather for evidence? What would be a good proof of violation?
Sure. So like I said, photographs are good if, depending upon what the violation is. Say someone is not shoveling, or, well, associations usually have snow shovel, but say someone's not putting their trash in the same spot, or they're parking outside of not where they're not supposed to park. Pictures do great justice. Again, affidavit, testimony by unit owners. If it's going to turn into a he said, she said, we show up to court with 5, 6, 7, or 8 affidavits of people willing to swear and say that that the board is correct, and that's powerful. Again, documentary evidence. If there's documents, if the fight is about some kind of documents that were either received or not received, all of those things compiled together make a strong case to back up your fines.
Excellent. Great answer.
So I want to cut in just for a moment so that everyone knows who's in the audience. One, thank you for all the questions. Two, the questions have blown up. There are probably 60 now unanswered questions, which while we were speaking was more like 5. So we will do the best we can. And to any we don't get to, we will try to find a way to get answers to everyone. But I just wanted you to know that, because we are never going to have a chance to answer 60 questions in the next 25 minutes. I did see a really good one that I wanted to answer. And we will, I guess, just pick and choose as we go through. Should associations have fully executed contracts with outside service companies? We have been pushing, probably for the last year or two, that associations are valuable clients, customers, whatever you want to call them. You should write or have written for you a both service and goods contract, so that anyone negotiating with you, for example, your landscaper, your snow plower, roofing work, siding work, windows work, they use your form contract. And therefore, because they're using your form contract, it protects you, because I'll tell you who their form bid and form contract protects: them, not you. So you would be so much better off in most situations if you have a dispute with the vendor and you sign their contract. A lot of times you have problems. Next, anyone?
I completely agree with that, Dan. And to add on, it's really sad because usually we're not hearing from associations when they're entering into the really big, expensive contracts. We're hearing from them when something goes wrong with that contractor that's a multi-year deal. And then they're saying, well, how do I get out of this now? They're not doing a good job. Well, guess what? You're probably stuck because if you signed their form contract, it's not going to give you an exit clause. It's not going to give you a way to terminate the contract. And it's certainly not going to give you a chance to recover your attorney fees when you've been paying all along and they're not living up to their end of the deal. So just having even an addendum, if you're not going to have a full contract written, we've done addendums that you can use generically for other vendors' contracts to tack on to them. And as long as the vendor agrees, those terms then will stick with that contract and protect you if something does happen to go wrong. So it's worth looking at. You're spending a little bit of money up front on an attorney review, but it's a lot less expensive than all the damage a contractor could do over a number of years at your association or what litigation could do to you.
So I want to take us back for a moment because one of our attendees, so thank you, commented relative to our discussion on the mask item. Keep in mind some unit owners / residents may be legally required that they don't have to wear a mask for health reasons or other reasons, which, by the way, you can't ask about because you'd be violating the privacy rights. Great comment. I see another question I wanted to make sure I got to. It says, what are some situations that have happened to board members, in your experience, if they selectively enforce the rules? I'm happy to take that one or pass that one, but my initial answer will be, one, board members that selectively enforce rules, it becomes obvious that they selectively enforce rules. So one, they lose a respect of the other unit owners. Two, they lose the lawsuits oftentimes because if you can bring in other situations where the rules weren't enforced, judges tend to vote against you. So now you've not only lost the respect of the unit owners, you also have a problem with, you've spent association money on the lawsuit and you've lost it. It's just a bad situation. Rules, and this is rules, bylaws, decks, are really simple. If you have them, enforce them, and you all have them. So if you have them, enforce them. If you're not going to enforce them, amend them and get rid of it. If you can't get the votes to amend something to get rid of it, for example, you have a declaration policy that no longer makes sense. It says, for example, children have to do X. It doesn't matter what X is. We already know it's illegal under the Fair Housing Act. Then have a board meeting minute that you put somewhere that says, we recognize that our declaration says X, Y, Z. We're no longer going to enforce X, Y, Z because we've been advised by our attorney it violates the Fair Housing Act, and therefore that is not going to be followed. And then everyone knows where you guys sit. But that's my simple answer. Lydia, any on the selective enforcement?
Jump in on one thing on the selective enforcement. From a litigation perspective also, the board needs to understand that if you selectively enforce or allow somebody to selectively enforce, you are essentially opening the association up to counterclaims for discrimination. So, it's not one of those things of just, one board member selectively enforcing and the other, board members turning the blind eye. If that selective enforcement goes forward and a counterclaim is filed, the entire association is going to be sued. And now we're going to be defending a lawsuit versus bringing one. So selective enforcement is not a good thing.
I saw a question in there. I think we handled selective enforcement. So great job, Dan and Kataj. I think that's covered. I saw a question that's been coming up quite recently and a lot is about security cameras. So somebody asked, is it okay for the board to put up security cameras in the common areas, or does that violate privacy laws? I would say the association board typically, per your documents, has full control over the common elements, meaning you can do what you want with it. It's your job to improve, maintain, repair, replace, and make all the decisions related to your common areas. So yes, you probably can put up security cameras. What I would caution, though, is make sure that you put a policy in place, whether it's in your rules or what have you. Typically, this would be in your rules and regulations about the use and who gets to see the footage from the security cameras and when. Because you're always going to have some nosy homeowners that aren't on the board that want to see footage for whatever reason. And if you don't have this policy in place at the front end, it's hard to say no to them. So if you're going to put up security cameras, let's talk about where they're going to be placed and put a policy in place about who can use it and for what reason. And typically, so you know, it's going to say the board and the management company can look at it, but only for investigative purposes. And the board will then have the discretion to allow the police to see the footage in certain circumstances too. Dan, have you had anything come up different than that?
Well, let me, on security cameras, here's what I'll tell you. Whoever asked that question was one of about 5 or 6 of these that asked about security questions. So thank you to all of you on the security questions. No, what you said is perfect. The board has every right to put up security cameras for both safety reasons, for fining reasons, for enforcement of rules reasons, for all the reasons people generically put up security cameras. Now, you can't put up a security camera and obviously point it in somebody's bedroom window. There's going to be problems with that. But making sure the footage is, one, maintained for some set period of time, and then 2, discarded in whatever fashion makes sense. And I don't know if that's a week or 30 days or what that is. But I know that's always the issue, is the cost of maintaining the space for all the footage that exists. So you're naturally going to end up into a loop of, at some point, how much time are you going to keep and what are you going to keep? But make sure you have a system that keeps it, and then ability to maintain it if you decide, wait, we know a theft took place last night. I want to maintain those 8 hours so we can look at it. That's it for me on that one.
Can we
Sandy,
jump back to rules for a second? And this has come up a lot. And Dan or Lydia, if an association has a long history of non-enforcement of rules and no documented fee schedule, but then fixes the issue, how do you begin to roll this out without being lynched, they said? So, you know, what's the repercussion? How do you do this?
I'm going to answer that one because I don't want there to be a conflicting position on that. And then anyone can chime in. If you have had rules that you have not enforced and are now going to decide to enforce them or have adjusted the rule to enforce them, you need to give notice to everybody and send it out. Give them 30 days and say, listen, I know we haven't enforced this rule. We are now going to enforce this rule. It's a new board. It's a new day. Starting March 1st or starting February 15th. I don't care the date you pick. Just give them notice and the opportunity to adjust whatever behavior they've been doing, and giving them 2 notices isn't a bad day. Don't forget tomorrow this goes into effect. That's what I would strongly recommend. And then it'll be enforceable and you've wiped out the, selective enforcement issue.
Yeah, I agree with you, Dan. I think communication is just key on that. And I love the idea of just putting it out there and acknowledging that this rule is on the books, but previous boards looked the other way or didn't enforce it. And now we're going to. And as long as you let everybody know that and they have time to adjust, you should be fine. And I don't think you'll be lynched as a board. Communication is your friend on this one.
And Sandy, here's a question for you. What is the order of foreclosure proceeds to the association? Lender, taxes, mortgage, etc.
Well, if it's a mortgage foreclosure, the mortgage company is going to get paid first. In most cases, they don't want to lose the property to delinquent taxes. So the taxes they have brought current. Any surplus over that, the association is next in line. If it is the association's foreclosure, then it would be the association, if there's a third-party purchaser, is paid its debt. Then the third-party purchaser is responsible to take care of the back taxes and the first mortgage to get clear title. Everyone after that would have been foreclosed out. Like if there's a second mortgage, that's foreclosed out in the association's foreclosure. So I hope that helps.
All right, I got another one. We can't get off security cameras, but that's okay. This one was, can owners put up security cameras without board approval? And one more on security cameras, and I want to look at what it was. Is it lawful for an association to provide camera access to all unit owners to common element cameras?
Dan, would that include a Ring doorbell? Because there's been questions on Ring doorbells also.
Right. And in my opinion, the answer is going to always be the same, which is if you're putting it up on common element, it's the board's decision because the board completely controls the exterior appearance. Notice I didn't say everything in common element they control, and they completely control the exterior appearance. So if you're putting it on the inside of your unit and having the camera facing out through your window, you are probably fine. As to the other half of the question of, can you give access to unit owners? Sure, you can. I'm not sure I recommend that because you're always going to get, I might put in a provision that says, on request, the unit owner may be granted access by the officers of the association. So if somebody had something stolen, they wanted to spend the 8 hours to look through the camera last night, fine, let them. But the problem you're going to have is you want that camera to be maintained and the information maintained in a fashion that you don't destroy the evidence or affect the evidence. So before I would let a unit owner even look at it, I would make sure I had a backup of it because I don't want it being accidentally destroyed. Because it could be the thief who's asking you to look, by the way. Oh, it happened to get destroyed. Okay, what else we got? We're on a roll, 9:47. We got more or less.
When an HOA expires and was voted not to be reinstated, what happens to common area maintenance such as pond and lawn care?
It's a mess.
Go ahead, Lydia.
I was just going to say it's a mess because if you don't have that document that, sets forth whose responsibility it is and puts one entity in charge of it, meaning the association by your elected board members, legally what happens is that's all owned in the percentage interest of your lots by the lot owners, meaning everybody still has their little slice of it, but nobody's in charge. So good luck to you. I mean, frankly, you'll have to just decide on a voluntary basis amongst yourselves who's going to do the maintenance work. And I don't know how you're going to get people to pay for it. I mean, this is why HOAs were invented in the first place. Well, there's probably quite a few reasons we could go through, but that's sort of the practical purpose. So you'll have to figure out a voluntary basis, maybe a rotation. Chances are it's going to be one or two people doing all the work and not getting enough thanks for it if that happens.
You might want to try to, even if you can't get the HOA to be back, if it's a particular, let's just pick something, a little park area, an entrance area, something, you might want to get the homes that surround it, if nothing else, to agree to deed restrictions that they have to pay for it. And if everybody does that for the part that's near them, or get everybody who is in the HOA to agree to just that deed restriction, I mean, something, that would be the ideal world. But Lydia's right. There will be those one or two who will refuse. And then you'll have those one or two who will refuse because the one or two refused. And they're not going to pay if these other people don't have to. So you run into all those problems. Wish we had a solution. No one will let me rule the HOA world, and just my decision matters.
Yeah.
Go ahead. Sorry, got way off track.
No, it's good. I saw a question about document amendments, which I thought was good. It probably comes up for a lot of folks. The question was to the basically saying, if you're doing amendments to your declaration and bylaws and you're sending them out to the owners for a vote, do the owners have to vote on each particular item or just the key changes within the document? And the answer is the owners have to vote on every change. But it gets to be pretty hairy if you have owners voting on each individual change, if you're doing a lot of changes to your documents at once, which, let's face it, many of your documents need a lot of changes. Getting rid of the declarant language and expansion land language and all those things that don't make any sense anymore since your owners took over control of the association. So for all those little changes, we found that it makes a lot of sense to do what's called an amended and restated document, where you're pulling together all of the amendments that were done over the years into one document and then further updating just that one document with the current laws and new language and electronic voting and virtual meetings and all that stuff you definitely want to have in there. So then when you present that to the owners, you would be presenting it for a vote as a whole, meaning everybody votes yes or no. It usually works. I've had some associations run into issues when there's some particularly contentious changes that the board wanted to make, say, related to animals, pets, related to rentals. So in certain instances, it might make sense to pull out just as a separate question a few of those sections, so it doesn't stymie your complete document amendment vote, but you can revisit those issues and have homeowner meetings and talk about it and try to figure out the best compromise on those things. But the answer to the simple question is yes, owners do need to vote on every change.
Lydia, there was a question also on, we have very old documents that have never been looked at. Do you think they should be reviewed?
Yes, I do. Yes, I do. Basically, because, let's face it, the law changes over time. If they're old, think how many times the statutes have changed since. So there's probably things in there that are outdated. And the problem with that is nobody knows what the law is as far as your association goes, because they're reading one thing in the governing documents and they might hear something else is in the statutes, and all you're going to have is confusion. So it's always best to get those things updated regularly, say every 3 to 5 years. Have a legal review and make sure that everything is still up to date.
And from a litigation perspective, we're following the governing documents are essentially a contract. So if some of those terms in the contract don't apply anymore, then we're kind of handcuffed in court. If the governing documents are tracking a law that isn't changed or doesn't exist anymore, we lose our case because it just doesn't apply. So I would say from a litigation perspective, to protect yourself, all of the governing documents need to be updated, amended to be updated to be current with the law.
Thanks, Kataj. I saw one I want to make sure we answer. Someone has asked, how do you handle repair replacement of things that are in restricted common areas when all owners don't have the use and when a special assessment is needed to repair? So one, I'm going to give you a little background. The background is this. It's clear that the special assessment is going to be used to repair a limited common element. A limited common element, restricted common element, whatever you call it, is by definition common element, and also by definition only used by some of the unit owners. And the answer to your question is it doesn't matter if it's by special assessment, by regular assessment, by use of the reserves, by use of your operating account. It still is paid for by the association. It may not seem fair. It may not be fair. I'm not arguing the fairness of it. I'm telling you, when you bought into the association, the documents provided what the documents provided. And you bought in knowing that oftentimes, some decks are larger than other decks. Nobody has a deck. Some people have patios. there's oftentimes many differences between the limited common elements of the various units. And therefore, you are stuck with what you bought unless you can get the documents amended, which is the biggest goal. But a great question. All right, we probably have time for one more if someone wants to pick one they want to answer.
Anybody see anything good? I'm going back in to look.
This is interesting. It kind of delves into what we were discussing with hostile environment at the CCAL seminar last week. In cases of inter-unit disputes, did the board request evidence of attempt at mediation prior to filing a formal complaint? Would this be part of the evidence maintained? So inter-unit disputes.
I think I can shed a little bit on this. You know, it depends on if the question, are they asking, is the evidence of the mediation going to be used as evidence at the board level decision or at the court level decision? Because if it's at the board level decision, then the board, you know, can take into account any type of evidence it wants. In court, it's a little bit different because evidence of settlement agreements and mediations and things like that, they're not admissible in a lawsuit. I mean, you can basically say that you had one, but as far as bringing into details about what happened at a mediation or how much the offers were, things like that, a court will not permit that to come into evidence.
I think the other part of the question. Sorry, Dan. You want me to go first?
Yes, please.
Okay. I think the other part of the question was, you know, can the board require that owners kind of mediate amongst themselves before they bring a formal complaint to the board? And I've seen that many times, just practically speaking, with boards saying to an owner, if they're complaining, especially about noise and that kind of thing, to approach the other owner that's causing the issue first and try to have a conversation about it. And I think that's a good way to go. I mean, frankly, if it's an owner-to-owner dispute, the board may not necessarily need to get involved if it can be resolved between the two owners. It's just when the one owner starts talking about something that's violating the documents, that's when the board needs to get involved. Then there's something to enforce. When there's something to enforce, the board has to get involved.
And I wanted to add one final thing. I think some of the problem with the unit-to-unit owner issues is related to someone not making a decision. I don't care if you require them to mediate. I don't care if you require them to talk to each other. But once that doesn't work, don't delay this process. Speed the process up. Just say, you know what, you two aren't getting along. We're going to have ideally your grievance committee, so not your board, but if it's your board, fine, make a decision. 3 of them are going to come. You bring whatever evidence you want to bring. We're going to have the hearing on Tuesday night at 7 o'clock. You guys can both bring your attorneys or not. We don't care. And you're going to present your evidence. The grievance committee is going to make its decision, assuming you have one, assuming your documents allow for one. If it doesn't, then the board's going to make a decision. And we're going to make a decision. That decision's final, period. And at least then there's a decision within a week or two, and it's done. And tell the people, well, we didn't think you had enough evidence, or we thought you had more than enough evidence, and we're fining you. Do something, because if it just festers for another 6 months, it's not getting better. All right, I think we're done.
And could we just cover one more thing? Because there's a question, is it best to update original governing documents prior to updating rules and regulations and establishing a fine schedule? I would maybe explain what order the documents fall in as priority.
Well, it seems that if you're going to create a fine structure, right, it has to be based off of your bylaws and your declaration, right, which kind of set the foundation for everything that's going on in the association. So I would say, Dan and Lydia might differ. I would say amend the base documents first, the declaration, the bylaws, the articles well, not articles of incorporation, but the declaration and the bylaws. And then based off of those terms, you build your rules off of that.
I don't disagree. I mean, you certainly need to make sure that when you're creating new rules, that there's nothing in the declaration or bylaws that's going to undermine what you're trying to do. For example, if you're going to put together a fine structure and your declaration has fines and set amounts in there, let's be careful. You might need to amend that declaration first. But as far as whether you need to amend the declaration and bylaws first before you put together rules and regulations, not necessarily. Again, you're just going to have to be careful that whatever you're putting together as a rule, as a board, doesn't directly conflict with something in the declaration and bylaws.
Completely agree. As your deck and bylaws get older, and for a long time, decks were next to impossible to amend. That has been fixed as of 2018, so you can now amend them if you want. It just, at some point, when it's 2 decades old, 3 decades old, you may want to take a close look at, do we need to amend these? All right, so that's the end of our seminar today. Thank you for joining us today. We hope the information was helpful to you and your association. To those of you whose questions we didn't answer, we will try to answer them as soon as this is over. As a reminder, this program is approved for Wisconsin Continuing Legal Education Credit and has been approved by a Community Association Managers International Certification Board to fulfill continuing education requirements for the CMCA certification. To report your CMCA hours on the CEU icon at the bottom of the screen. A certificate of attendance will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And we're just telling you right now that the next program is going to be May 26, 2021. In part, we're going to have an environmental attorney who does environmental / city issues and work, because we get so many questions about that, and they've been extremely busy the last year. And because this time slot was so heavily attended, we will probably use the same time slot. So May 26, 2021, 8:30 a.m. to 10 a.m. This concludes our webinar. Thank you so much for being here.